Please have appearances of council, please. Good afternoon. Can I please get appearances, please?
Yeah. I'll sit right here. Yeah, you can sit over here.
Hi. Your phone's on silent.
Yeah.
Yeah, that's right. I would.
Everyone on Blue Jeans, I please need you to mute yourself. Can I have everyone please check in?
Sure.
Is it?
No, certainly. Thank you.
You're gonna say something.
You got it. I will probably read your style rather quickly, but I know better than to try to distract you unless it's urgent. So,
Right. If there's something, please feel free. You can handle it.
okay. Small kids. Yeah, let's take it.
I don't know, Judge Kitchen would get upset. Oh, now it's fine, yeah.
I'm Daryl Dennis. Nice to meet you. Gus Flying Gus. Nice to meet you, sir. Daryl Dennis.
Hi, Kim Stein.
Nice to meet you.
Nice to meet you.
Hey, thanks.
I know.
That's a shit.
Yeah, let me.
I found some cups from the front corner of my house.
Is everyone here who's going to do a hearing that needs to be?
Yes. What's up?
I'm getting on the phones.
Here. No, you just showed it to me. I had it. No, where it's missing. I'll just make it. It's not there. Sorry.
District Court 27 now in session, the Honorable Nancy Alf presiding.
Thanks, everyone. I guess we couldn't get all the lights on. Okay. Thank you. Please be seated.
Good afternoon, Your Honor.
Let's take appearances, please, starting first with the plaintiffs.
Daryl Jemis, appearing in Polk Park. Good afternoon, Your Honor.
Thank you.
Shad, Vick, also plaintiff.
Thank you.
Thank you, Your Honor. Kimberly Stein and Gus Flangus on behalf of the defendants, Vinco Ventures, Roderick Vanderbilt, Lisa King, Brian Hart, Jesse Law, Richard Levitchin, and Theodore Farnsworth. And also present with us today is Mr. Law in the courtroom, and Roderick Vanderbilt, Lisa King, Brian Hart, and Richard Levitchin are all present via Blue Jeans. And Mr. Farnsworth will be joining. Unfortunately, he was caught with dental surgery. So,
All right. So give me just a second to get booted up. There's a short trial next door, and I just need to be able to get up.
And Your Honor, there is another plaintiff that's attending in Blue Jeans, Christopher Muntz.
Okay. Mr. Muntz, do you have your audio? Oh, this is... All right. It's not going to let me get up. You know, I think we can go next door. They're just finishing up. I need to have access to my screen. Sorry. I think we can set up next door.
Your Honor, consistent with what you just said, will we be able to see Mr. Muntz on the screen next door? I'm assuming so. Your clerk is nodding
It's
yes.
the same system. Yeah.
Okay, great. Thank you.
All right. Sorry for the confusion, everyone. Let's just get set up next door. I do see some other lawyers here. Are you observing?
Yes, Your Honor.
Okay. All right, the court will please come to order. Let me recall the case. We'll take this again, please, on the case of Vick versus Vinco, starting first with the plaintiffs.
Shad, Vick.
Daryl Jennison, Proctor.
Thank you. Mr. Muntz, are you on the phone?
Hi, ma'am. Yes, I'm on Blue Jeans.
Thank you. Do you have video? Yes. And for the defendants, please.
Thank you, Your Honor. Kimberly Stein and Gus Flangus on behalf of the defendants, Vinco Ventures, Roderick Vanderbilt, Lisa King, Brian Hart, Jesse Law, Richard Levitchin, and Theodore Farnsworth. And Mr. Law is present with us in the courtroom today.
Thank you. You're welcome.
And Mr. Vanderbilt, Ms. King, Mr. Hart, Mr. Levitchin are all with us via Blue Jeans, and Mr. Farnsworth will hopefully be joining later, but he got held up in dental surgery.
Of course. All right. So I just wanted the record to be complete here. This hearing is on so little notice that I want to treat it probably as a preliminary hearing. But plaintiff, please outline the relief you're seeking.
Yes, thank you.
I've read everything, but there's a lot here going on.
Yes, Your Honor. The most draconian measure that we're seeking would be for the court to order that the shareholders meeting that's currently scheduled to take place on April 27th be ordered not to take place until further order of the court. However, as I just indicated, I think that's rather draconian, and there are other less draconian ways to address the needs of the plaintiffs. And those would be in the following order, and this is ascending. So block the meeting entirely, and that's not really what I'm seeking. If we can find another easier, softer way. One of those would be for the court to order that they can't hold the vote on items 1 through 11 inclusive. But I don't think that that's necessary, because item 1 is either to vote back in the existing board with a yes vote or to abstain. There's no option to vote them out. And so I don't see a harm in people either voting for them if they want them or to vote to abstain if they want. But we're going to have to address that issue at a later date. And so the least draconian way to deal with this, I think, is for the court to say you can hold the meeting and you can take a vote on action item number 1, and you can take a vote on action item number 11. Item number 11 seeks to have shareholders approve review of compensation for directors at either 1-year intervals or 3-year intervals. And again, I don't see a harm in taking a vote on that. Action items 2 through 10 inclusive all negatively impact common stock shareholders in a way that would cause irreparable injury. And so I feel that at a bare minimum, it would be necessary for the court to order that the vote on items 2 through 10 be stayed until further order of the court. And we'll address why at a later point in detail why I feel that way. And then finally, there's a request that the court order Vinco to contact the stock trading listing agency, NASDAQ, New York Stock Exchange, either both, whatever is appropriate, as they apparently did in the past, to order all trading of all equities involved with Vinco, whether it be common stock shares or whether it be futures, whether they be calls or puts, until further order of the court. And I think ultimately that would be important, and it may be appropriate to make that order here today, or it may be something that we want to come back and revisit very soon. And then lastly, there is a request that a receiver be put into place. Now, we don't have an investment in requesting specifically that Ross J. Miller be appointed. The reason that we named him by name is because in the first incantation of this lawsuit, that's what happened. And so he's familiar with the parties, he's familiar with the problems, and he, I think, would be a good choice. However, there is a conflict potentially, because apparently there's an issue of non-payment and there's a lawsuit that was filed, and so it could be argued, and probably would be argued, that he could be conflicted out, but that's a conflict that could be waived. And if it can't be, I see that Ms. Stein is shaking her head no, but that's kind of interrupting me. That's something that you can determine. I have great faith that you will listen to both sides and you'll make a ruling that is fair and just under the facts and laws. You understand it?
All right. Is there a brief response?
Yes, Your Honor.
Oh, yes. There was one other thing. I'm sorry, Ms. Stein. My co-pro per plaintiff reminded me that we want to have a special master appointed for purposes of vote. And that would be especially critical if the court were disinclined to stay the vote on items 2 through 10. And we can articulate in more particularity the reasons why we feel that is an absolute necessity.
Thank you.
Anything else that you want to add before? I don't want to interrupt Ms. Stein again.
Ms.
Thank you.
Thank you, Your Honor. First of all, I want to deal with a couple of housekeeping matters. We requested cost bonds in this matter, and they filed apparently.
Filed?
Well, they filed something last night without serving us, but they did not file proofs of receipt. And when we look on Odyssey, there is no proof that they actually delivered the check to the clerk's office and there was a receipt of payment. So there's a check, and again, we weren't even served with this. We had to find it this morning, but they supposedly filed that, but we don't see any proof that it was actually posted with the clerk's office. And unless it's posted, we don't believe we can go forward as a matter of housekeeping.
Have you seen the pre-printed receipts that were filed?
No.
Do you want a chance to boot up and see those?
We tried to pull them, Your Honor. The only thing we pulled was a copy of a check, and they said that the receipts were with the clerk's office.
There's something filed.
Okay. That was last evening, right? That does not have receipts attached. They say in that those receipts are in the clerk's office. It only has a check attached.
All right. And are you prepared to respond to that,
Yes.
Mr. Jennings?
So we actually never received an order for the court as for a bond amount, but we still went ahead just because of the priority of the issue and
No,
paid the bond.
this is a statutory, they had the right to make this demand.
I understand. And we did make the bond payment and we did file the receipts, but the statute that was listed didn't indicate that we had to put the receipts in.
Don't go into that. The question is, do
I have-
you have them with you?
Well, we filed
The
them.
statute.
Do you have a copy with you?
Yeah, I should have. Okay.
Do you have a copy with you? Please produce them and we'll hand them to Ms.
I
Stein.
left those at the.
Okay.
There's nothing from the clerk's office showing that there's anything been filed, Your Honor, that they have a receipt, because it would show, as you know in Odyssey, that there's been a receipt of money and there's no receipt of $10,500.
Your Honor, if I could just address this really quickly.
Does somebody have a laptop to boot up so she can see?
I can pull that up.
While Mr. Vick is pulling that up, we came to court early yesterday, specifically to make sure that all of that was in
I
order.
saw you in the courtroom yesterday.
Yes, ma'am. I was not in a suit and I tried not to be disruptive, but
No, the court's always open. We do
I
people's
understand.
work here.
yes. But what I was saying is one of the reasons that we came yesterday was because of the fact that I'm not familiar with the local rules and procedures, and I wanted to make sure that if there was anything that I needed to do to make sure that this hearing that you put on calendar on special notice would not be disrupted. So we found out that the bond issue was, in my mind, it wasn't really super clear. I read the statute. It actually uses the word may, permissive, not the mandatory shall. But everybody speaks to it as though it's mandatory, and so I'll accept that. I'm not here to argue about it. We posted it, they gave us receipts, and unfortunately, I wasn't able to make copies of the receipts last night. I believe we made copies and refiled it again as a declaration this morning with the receipts attached. And my understanding was that when the clerk got it, that they would email everybody, and that way Ms. Stein would have it directly. But apparently that didn't happen, I don't know. But anyways, let's get the receipts.
We did post a declaration with the stub that was recorded to the court, and we do have receipts here that show that was paid yesterday, if you want to see those.
And your comment, please?
I'm asking for the receipts because they have, and I'm also asking that they had an issue with service, and we're not going to go further into that, but they didn't serve us with anything. They haven't shown they posted it. I need to see the actual receipts. I would also ask that they continue to actually serve us if they're going to do documents. More importantly, because of a prior court, they continue to serve my clients. I asked them not to serve them because they're represented. But I would ask, as a housekeeping matter, apparently from the clerk's office, we can't take off the service of my clients. They can actually go in and take me off, but when the court's serving, I need an order from the court as a housekeeping matter to take off my individual clients from the service slip, if that's okay, but if they would please show me the receipts, I'd be fine, but they're not filed with court, and we need those, as you know. I need to see that before we move forward.
Okay. Your Honor, while Mr. Vick is showing the receipts, as a housekeeping matter, I would think that if we're filing a bond or posting the bond with the court.
There's too much going on here. These two need to be able to talk.
Okay.
They need to be able to hear anything that's said. You know, why don't I take a 5-minute recess so that you guys can have a chance to look at that?
Thank you.
And if for some reason that doesn't work, you can come up here and use this screen. I'll be back in a few minutes or as soon as you're ready.
Thank you, Your Honor.
Can you open it as a PDF? But you need to file on notice. I'm just telling you going forward, it's not an argument point. And you cannot serve somebody and file something. Much like you order a plan. You cannot serve. Why don't you put it on to me since you know how to? I'm asking you to follow the law.
Don't pay into it. I understand, but the judge isn't, you saw how she didn't want to hear that. I started talking about permissive versus mandatory, she didn't want to hear that. Why what? Why wouldn't I? I don't know. Doesn't say the receipts. Yeah, that's true. The statute doesn't say the receipts are required, so. The bottom line is, it's a non-issue. We filed it, we have the receipts, and she's now saying, what's the problem now?
Hey, Daryl and Shad, this is Chris Muntz. We can hear your mic. I don't know if you can mute the mic at your table.
Thanks, Chris.
Sorry.
I love it.
Oh, thank you. It turns red.
Is it won't ever do? You have permission for the sleeves?
Yes, this is it.
Well, it's well tolerant.
Now I feel cheap.
No. We have the receipts and you showed it to them.
I just put my sorry doing it, but I do, yeah, because I don't want.
It's okay. We just want to talk.
Yeah, thank you so much.
That's easy. I'm sorry. I should have introduced myself.
Amy, I'm Daryl. What's your last name?
Sugden. So I was working with Ross when he was appointed.
Oh,
That's why I wanted just to come down here.
Awesome.
Hi, nice to meet you. Trying to stay out of the mix, but also aware, if that makes sense.
Yes, thanks. It's a pleasure to meet you.
You too.
Very.
The question is, okay. Stop. Not the notification. I would pay that. And she said, well, you. I start talking about all that. I'd rather just leave that. But we didn't include the receipts last night. So no. Another way to do that is to just say, now that she's seen the receipts, does she have it? I understand. I'll tell them that now, but
Department 27 back in session.
Thanks, everyone. Please be seated. Ms. Stein, did you get a chance to look at everything?
I did, Your Honor, and obviously we could move forward. I still think that in the future, I would ask that they, one, file it correctly, and two, serve us with a copy of it, because again, we didn't have anything, and we still haven't technically been served with anything, but we're fine to move forward.
Yeah.
I do have another housekeeping issue I do want to address, though, and it's also very serious to us. Mr. Jennis, who is clearly speaking here for the three plaintiffs, is, as the court is aware and it's filed in our papers, is an attorney. He's suspended in the state of California, not licensed in Nevada. It appears he's continuing to practice law by representing, but there's more troubling is that on Twitter today, they posted, and if I may approach, Your Honor.
I haven't seen what counsel's trying to show the court.
I have a copy.
Make sure that Mr. Jones, or is this two copies?
Yeah, one was for him. I apologize.
Our marshal's filling in today, so.
Yeah, sorry about that.
Thank you.
So, Your Honor, exclusive DUI is Mr. Jennis. And what's most troubling, if you go to page 2, they actually post a picture that was supposed to be of our law offices. Unfortunately, what they did was post a picture of Mr. Flangus' cousin Leo's office, as you're aware. And
Drives by it every morning on the way to work.
but if you continue to go through this thread, he talks about not only representing and how he's going to represent all these people. I'm going to get into that in a moment. They also, there's a post if you go through, and it's actually referencing Saul, Saul, and it says, it's better off Saul, I think is the show, I'm not positive, and it says, I'm way better than Saul, but if you look, there's a guy behind going to hit the attorney. We take that very seriously. We're very concerned. We let Mr. Leo Flangus's office be aware of it, but we have concerns on the actions of Mr. Jennis, who's also been part of his probation in California was because of his actions in a courtroom against prosecutors in a case 4 different times where he was caught on video taking certain actions. So we would just ask the court to take notice of that for the future, and hopefully that we can act professionally as we go forward.
No, there is a First Amendment. You can violate it. But in cases in this courtroom, even in very high conflict cases, I do not allow anybody to act out in the courtroom. And if you do, there are consequences. All right. So,
Thank you.
Mr. Jennis, you realize you have the right to represent yourself. You do not have the right to represent the other plaintiffs.
Yes, Your Honor. What counsel has just said to the court, I'd like to address because of the inaccuracy of her comments and the gravity of the
There will
comments.
be no personal attacks at any time in this courtroom where you'll be escorted out.
I am not going to attack anybody, but I'd like to address the attacks that have been levied against me.
You can respond.
Thank you. Okay, first of all, I'm currently on a 24-month suspension, which is what's called a referral case based upon.
I don't really care. You have the right to represent yourself.
Yes, I do. Okay, so let's just say that I categorically deny both conjunctively and disjunctively every spurious accusation that Ms. Stein has leveled against me on the record, and I find that that is inappropriate, unprofessional, and violates the Nevada rules.
I don't want your opinions. I don't want your
She's trying to
opinions,
intimidate me.
and
It's
I
not
don't
gonna
want
work.
any. No, I'm not going to allow any name
Thank you.
calling on either side.
Enough said on that. Now, can I address these documents that counsel provided to you?
Okay.
Okay. So I appreciate what you said about the First Amendment and my right to represent myself. I do want to say that I do not represent anybody but myself. We have 2 other improper plaintiffs. Mr. Vick is present physically and Mr. Muntz is present virtually. And we have worked together and we have written these documents together. And yes, I do have a legal education. And yes, I do have a lot of experience in litigation, albeit not in Nevada and albeit not in civil. However, you can't remove that knowledge and that experience from my person when I'm representing myself here in pro per. I know you appreciate this, but apparently Ms. Stein is not appreciating
personal
it.
attacks.
Okay, I'm not
If you do it
attacking you.
again, I'm going to
Okay.
kick you
All
out
right.
of this
Well,
room.
I've said enough on that, but with respect to these documents that she's just provided to you, if you're going to take the time to look at them, and I don't think that you need to, you'll notice that most, if not all, of what she's posted, I didn't post it. Somebody else did. And the first page is a picture of a website that is not currently on. In order to get this picture, she would have had to go to the Wayback Machine. And the reason I say that is because in order to be in full compliance with the state bar in California, immediately prior to August 28th, the beginning date at midnight, I think it was midnight or the 27th, but regardless, about 7 months ago, I instructed my webmaster to take all my websites down so that I wouldn't be falsely accused of holding myself out as being available to practice at a time when I'm not available. So I do find it a little bit suspect that she leads out with a picture of a website that cannot be accessed.
If you suspect, you have to govern yourself in a better way in this courtroom. There will be no attacks, no name calling.
I'm not attacking anybody. I just think that
3 times.
Okay, I think that when somebody puts a document out that purports on its face to be a fair and accurate depiction of what you would see if you went on the web yourself right now, that is at a minimum misleading. It's not the case. If you type in exclusiveduidefense.com, you're going to see that you can't access the website. The only way to access and pull this picture up would be to go to the Wayback Machine.
Okay. Did you have any other housekeeping matters?
No, Your Honor, I just want to make clear for the record, this is a printout from their Twitter accounts that were on the web today. We didn't make up a way back, and I know you understand that, and I would not do that. I want to make it clear, it's not a website, it's a Twitter. And I just wanted to make that aware for the court and also for the bailiff, because we did have, and I do have concerns, obviously, as well, based on that. But I'd like to move forward, and I think this goes to the point, and let's go to the merits. I know the court is busy, and I respect the time. First of all, this is not a derivative claim. This is 3 individual shareholders. And that's really important for both motions that they try to bring. And I want to also bring up, we've never been served. There's never even been service process. There was no summons issued.
And I did, in the order setting hearing, indicate that service was required. And if you have an objection to going forward today, even though you filed things, then we will continue it till next week.
And Your Honor, I'd rather go forward. And we're fine with that. Our understanding is because, unfortunately, because Judge Sturman issued the hearing, and we do appreciate the hearing because it's also ex parte, and I know the court wants to hear it, and it was served on my clients, hence why we quickly also requested transfer to the business court. Then actually it was assigned to Judge Denton. They did a peremptory, we're here, which is fine. The issue was then we had to rush to get oppositions, and if you note, I know you talked about earlier about treating this as a preliminary injunction. We only did it as an opposition to the TRO because we do plan to do motions and all of that. I know you also said service. There has not been service because there's not even been summons issued.
That's why when I got the courtesy copies yesterday, I was surprised.
And what we are going to do as well, Your Honor, with regards to the service, is we still will make those rights when we bring our proper motion to dismiss. But I want to go forward on the fact and why it's so important that there's only 3 plaintiffs here is because what they're asking for in relief on their injunction is in reality affecting every shareholder of this company. This is not a private company. This is a publicly traded company on the NASDAQ. And they don't have the standing to do that. And as this court is aware, under the statutes and under NRCP 23.1, to do a derivative claim, you also have to do a demand, and there's certain procedures you have to follow. And that's automatic under Nevada law, as this court is aware. And as such, we are not able, in our view, they cannot get that relief that they try to seek. And as a matter of fact, as this court is aware, and I'm trying to just get me one document here, apologize. To determine whether a claim is direct or derivative, the court must examine who suffered the alleged harm, the corporation or the suing stockholders individually, who receives the benefit of any recovery or other remedy, the corporation or the stockholders individually, and that's parametric Sound Corp versus Ace Judicial District 133 Nevada 417, and that's in 2017. And again, under the Schoen case, again, NRCP 23.1 imposes a heightened pleading standard on a shareholder bringing such an action. And because the power to manage the corporation's affairs reside in the board of directors, a shareholder must, before filing suit, make the demand on the board, or if necessary, on the other shareholders to obtain the action that the shareholders desire. And that's shown the SAC Holding Corp 122 Nevada 621, and that's in 2006. And I know the court's aware of those. And that's because that's important, is we don't believe that they have the standing to bring the motion that they've brought for the temporary restraining order and or preliminary injunction. Importantly as well, they talk about harm, but they don't talk about is the balance of harm. And they don't give us any examples of how they'd be harmed. And I'm going to give an example. Today we hear, well, you know what, we're not trying to stop a meeting, but we want to stop certain votes. But they don't tell you what those votes are. One of the votes in that 2 through 10 that they say can't go forward is to ratify the auditors. And again, what they also don't tell you is they're asking for relief they're not entitled to as shareholders. They're entitled to go to the annual meeting. They tried to get their own slate, these 3 individuals, of directors incorrectly through a lawyer that they says that doesn't represent them, who filed into this case. But what they don't say to this court is that they're not entitled to that because they didn't follow the proper procedures. This is a properly noticed annual meeting for a public company through proxy. So what they don't say is they couldn't do that. They also don't say is they have every right to show up to the meeting on the 27th. The problem is they know that the three of them don't have these type of votes, and I'm going to go further into that in a moment. So they're trying to come to this court to circumvent this because they know that they probably don't have the votes to undo the actions. But that's the risk of being an investor, a shareholder in a public company. You have a vote, but you don't get the remedy. And what they're coming to this court to do is get a remedy they're not entitled to as shareholders. They have no standing to do so. But they also don't talk about the harm. The harm is this company, and there's a long history of the company, and I'm familiar with it. I actually was involved in the company under Judge Williams' case. I was actually brought in by Ross Miller as corporate securities counsel in Nevada, because I worked for Mr. Miller when he was Secretary of State and I was Chief of Enforcement. And the reason that this is important, Your Honor, is that right now they're arguing harm, but they don't tell us what the harm is. But this is a $60 million cap company. This is a company that has, with the NASDAQ, a letter, and we attached the 8K. And what's important about that is, according to the requirements to remain listed and not be delisted, we must have a meeting by April 27th, 2023 to regain compliance with the shareholder meeting rule. And it's ironic, Your Honor, because I've come to court a lot of times when companies don't give me an annual meeting, asking for that meeting, as you know, under NRS 78. We're getting the opposite here. They want to stop a meeting. But this meeting has more implications than these three plaintiffs. It affects the company and the listing of the company. That also goes to the bond argument. And why is that? Well, they say they don't want any bond, and as you know, under NRCP 65, you have to have a bond if you get an injunction, and I would ask it not interrupting.
Your Honor, I'm going to interpose an objection, and this is not relevant because we've already gone past the bond.
All right, so,
Also, I thought you wanted an opening statement.
please don't interrupt me. There will be no interruptions. I won't let her interrupt you. You don't get to interrupt her. Overruled.
Thank you, Your Honor. And again, as we're talking about the bond under NRCP 65, which, as you know, different. But what I want to address is they're saying no bond. We know it's required, but then they're saying a minimal bond. They're affecting a $60 million cap company, and if it gets delisted, Your Honor, minimally 10% of that is $6 million if they would want an injunction to stop an annual meeting, which will cause a company to get delisted. So, again, it's not a minimal bond. And again, the remedies they're asking for is actually against their own interests. So when we weigh the harm, and there's no harm that's been provided to us in any detail except conclusory statements, the harm here is not to the plaintiffs, the three plaintiffs. Again, we're not here on a derivative claim. It is to the company, to Vinco Ventures. And this also then goes into, Your Honor, their argument about a receiver. So first of all, I want to address, and now I hear, well, you know what, we'll let it go with regards to Ross Miller. But I want to address that because we did do an opposition. And the reason we did, Your Honor, is, well, first of all, if you look at both of their pleadings, under the TRO and preliminary injunction, they do cite to NRCP 65, but they don't cite to any other law. Under the receiver, they don't recite to any law. So when we did our opposition, we did it to NRS 32, but I also want to talk about NRS 78 in a moment as well. But with regards to Ross Miller, what they're in reality asking for, and by the way, he was not a receiver in Judge Williams, and I don't know if the court has seen, there was a stipulation and settlement agreement that was signed by Judge Williams where Mr. Miller was actually appointed the co-CEO. And if you read that, what they don't talk about is it says, Miller shall be the sole CEO of the company. Miller and his team, which may include Gabe Hunterton as president, shall run the company subject to the oversight of the company's board of directors. And we've also heard he has a lawsuit against the company because there was an issue. He is no longer with the company, and now he's suing the company. His lawyer's in the courtroom today. What they're actually asking for is to have him appointed, even though he wasn't a special master or a receiver in Judge Williams' courtroom. They're asking without an affidavit, which is required for a receiver. They're asking that we appoint this gentleman, that it's a waivable conflict. But in reality, with an ongoing litigation, he could terminate the attorneys, and I'm not his attorney. or the company's attorney in that matter, because I do have conflicts, what would happen is he could actually fire that counsel and settle the lawsuit with himself. That's what they're actually asking for. So now then they try to come to this court and say, well, you know what? I'm going to back off of that too. So I just want a receiver or a special master, which they don't ask for in any of their papers. I want to go through that a little bit. Again, to even get to a receivership, you have to show something. Now, under NRS 78.650, if they were over 10% shareholders, which they don't allege, they could try to seek a custodianship. Or you could even go under NRS 78.347, but that requires an affidavit and insolvency or such a dispute with management. We don't have that here. Matter of fact, they first of all argue that the company, they don't argue it's insolvent, and I can make representations to the court as a public company that there is no question of insolvency of this company. That's not an issue here. I can tell you the company has sufficient funds, and hence why it's trying to get its listing to be able to continue. Because if it does get delisted, actually they could have a creation of a problem of insolvency, which is what I think that they're trying to create here from the remedy they ask for. But what we also have here is we have new management, Your Honor, and it was announced actually on a press release, public company, April 20th, 2023, where the board approved new executive leadership, which is naming Mr. Robertson as CEO and president, and Chris Polamani as CFO and COO. Now, the board has to be, as you know, under 78347, the board has to disagree. We don't have a board disagreement. We don't have a derivatives request, and we don't have any disagreements. The disagreement is 3 shareholders that are coming to this court arguing, we don't like it. Now, to keep going, Your Honor, is, then they say, well, we can have a special master. Again, they don't say why they need one, but what they don't talk about again, and this goes again to NASDAQ. This is extremely important. The company has been in issues and negotiating with NASDAQ to remain listed. There were several issues with the company. And it is a requirement during this exception period with NASDAQ, as per the AK, that the company has to, if there's any changes, not only have the meeting, but before July 7th, demonstrate compliance. And during this exception period that we're in currently, any change is called a significant event that occurs that affects compliance, which this clearly would do and a receiver would do. And then it includes any event that calls into question the company's ability to meet the terms, would take away the exception period and delist this company. So again, we're faced with 3 individuals asking for a remedy that actually is against what they really want in the end. So we don't understand why we're here, quite frankly. And so again, Your Honor, I think, and we can go through, and I don't want to waste a lot of more time on that. They have this argument, and you'll hear it, I believe, that they believe that the company is bad, they don't like this Mr. Farnsworth, that he's a bad man, so you need to put a receiver. Your Honor, what they don't talk about, and it's a public document from the United States District Court, Southern District of Florida, is the conditions of release for Mr. Farnsworth in his criminal action that's pending in that district. Now, as we all know, that trial has not set to begin. Mr. Farnsworth was indicted in a criminal action on a securities action. But that action is not to be heard till, I believe now, March of 2024.
A charge is just a charge.
That's what I was going to say. Thank you, Your Honor. But I also want to read something to you, which is from the docket in that case, and I have a copy if the court would like. Okay. There's additional special conditions of the bond, and why this is important and relevant. Number 3, Mr. Farnsworth is prohibited from the sale, offering, or promotion of any securities, including debt, equity, or hybrid securities, without the permission of the government or pre-trial services, except for any securities of or relating to Zash Global Media, Vinco Ventures, Inc., or Icon Publishing, or any affiliates or subsidiaries of these entities, or any transactions relating to or involving Zash Global Media, Vinco Ventures, Inc., or Icon Publishing, or any affiliates or subsidiaries of these entities. The government looked at Vinco Ventures. This is why we're here today. They said there was nothing wrong with Mr. Farnsworth being involved. So their whole arguing, well, he's been indicted. Again, the government has investigated Vinco Ventures with regards to Mr. Farnsworth and does not have an issue because his condition of release on his bond was that he's allowed to be involved with this company. So again, there is no harm here that they can allege by allowing this meeting to go forward against them. The harm in reality, and again, we don't hear details, we keep hearing different things, but the harm again is to the company, and if the court is inclined to grant this bond, to grant this TRO, we need a bond, because again, the company would get delisted if we do not are allowed to go forward with the meeting, as has been noticed. And you can't just change the notice and say you can't vote on certain things without certain procedures. This was a proxy annual meeting for a public company with notice that's been properly noticed. There's been no allegations otherwise. And I ask the court if they have any other questions.
I don't, thank you.
Thank you.
All right, let's start fresh, Mr. Dennis.
That's a lot to unpack.
Uh,
You want to talk first? Go ahead.
If I may, Your Honor.
Of course.
So I'm a layman in this case, I'll admit it, okay? I live in Georgia. I'm a shareholder of 236,500 shares. Not just about a year and a half ago, our market cap was $3 billion. It's now 60 million. It's declined that much. I build websites for a living in software. And when I saw what was happening with this company, I reached out to Vinco Ventures many times through the appropriate channels. They have an email that you can reach out to. I've never received a response to them. So when I saw that there was no way to communicate with the board, I went to other online sources to see if anybody was engaging in the same problems. I found there's online investor communities. And so I started to find people who had the same concerns. Emails not getting answers, no response from the board. These are the people who are supposed to advocate for us as shareholders. That's their number one responsibility. So I built a website. Next thing I know, I built this website in December. Next thing, it's called bbigfamily.com. We now have 1,450 shareholders who put their name, email, phone number, and address on that website. And many of them have put the number of shares that they hold. And to date, we have almost 50 million shares represented on that website. Now, I know I don't represent them, but these shareholders collectively tried to find a way to stop what's about ready to happen. What is about ready to happen with this shareholders meeting would be that if these votes go through, and even though we know we have the votes to stop them, we know that the accountability over the stewardship of the shareholder meeting and vote is by a board who we believe doesn't have our best interests. So one of the things that would happen is diluting the shares even more. We've gone from, like I say, a high of 12 down to 25 cents right now. We are certainly worried about delisting from the NASDAQ. But my intent here today is not to hurt Vinco Ventures. I want Vinco Ventures to succeed. That's the only way I can get my money back. That's the only way all these other shareholders can get their money back, is if the company can actually succeed. So I was nominated by fellow shareholders, by these 1,400 basically. We get together on conference calls of 1,000 people, if you can imagine. Twitter has a function where you can do a conference call. It's called the Space Call, where hundreds and thousands of people meet regularly. And I was nominated when the pre-14 came out. We did retain a lawyer who was a shareholder. His name's Patrick. He works with Shoemaker out in North Carolina. We retained him. We didn't retain him for any of this. Let me finish.
What did you retain him for? Not
We
this.
retained him to help us get through the nomination process, his firm. And we followed the procedures in the bylaws. Now, you need to know, we haven't had a shareholders meeting since 2021, since the fall of 2021. We have begged for a shareholders meeting. They haven't given us on-time filings. That's why we have been warned by NASDAQ of delistment, not just because of we're below $1, because they haven't filed their quarterly filings. And they still haven't even given us an annual filing, and they want to do a shareholders meeting without having an annual filing for the year 2022. So you can imagine, how could we possibly vote on anything without even them doing their job? They're required to give us a shareholders report for 2022. We don't even have fourth quarter or the last quarters of 2022. Excuse me, I'm a little nervous.
Relax.
But I just want to say, I submitted in my declaration, there's also 4 other shareholders who submitted declarations. We've done hundreds of hours of work putting together this information, but not by ourselves. With these hundreds of other shareholders, we've crowdsourced this information to put it together. And here's the key. I agree with you 100%. Nobody is guilty until they get through their case. But there are some serious charges by the federal government on Mr. Farnsworth. And it's for doing things with securities with a previously publicly traded company that was driven to bankruptcy by the same tactics used here, by dilution of shareholder value. And I can't get into all the details of what happens with hedge funds and dark pools and all. That's not the case here. The case here is we are attempting to do anything we can. I would do anything, no offense, to have an attorney that's a securities attorney representing me. We rushed to find one. You wouldn't believe how many attorneys in Nevada have already had conflicts because they've worked for Vinco. So we said we got to do the best we can with what we've got. So we're going to go pro per. We started a fundraising campaign and people have put together money. We're soon going to have enough money to retain the type of attorney that we would need to fight for ourselves and for our company. We're not trying to hurt anybody. Excuse me, if I may. I'm overly passionate. I don't know the board members personally of Vinco Ventures, but I do know that most of them have been personally appointed through Theodore Farnsworth. He's worked with them from Zash, a private company, and they show as independent directors. For example, Brian Hart and Jesse Law show as independent directors, but they actually worked for Zash Global Media with Theodore Farnsworth presently. There's also ties to Lisa King. She's previously worked with Theodore Farnsworth. Theodore Farnsworth himself was a co-CEO of Vinco Ventures, and now he's back out in the private world, and right now he's trying to ink a $100 million deal to buy the National Enquirer. He's put press all over the New York Times and other news outlets saying that it's done. We actually believe he spent the money already. I don't know how he can make this happen because it requires a shareholder vote. And so that's one of the items on vote here. We're simply asking for this. If I could sum it up, we're simply asking to take our company back because we know we could do a better job. And we would nominate a new group of people. And if the shareholders collectively want to vote for the previous 5, then so be it. We would be gone. But if there's now new nominees on there and the shareholders vote for those new nominees, that would help. We would be able to turn things around. The nomination that we put through, we did follow the rules. The technicalities that they pulled through. Now think about this. They haven't had a shareholders meeting. They've skipped it for almost 2 years. And they're not able to get out filings on time. But within just 2 days, they were able to put out almost an 18-page document saying why we didn't do things right with the nomination process. Things like this, very petty. You are required to have a personal address as your address as a nominee. It doesn't even say that in the bylaws, but they put that. And I didn't have the money or the capacity at the time to fight it. But I wanted to at the time. I wanted to fight every single one of those items that they put down that they said we did wrong.